Hi, welcome to our webinar, Immigration Advocacy 201. And my name is Ty Sinavan. I am the Program Advocate Support Manager at Standpoint, and presenting is Rachel Kohler, who is our immigration attorney here at Standpoint. For those of you that don't know about our organization, Standpoint is a statewide organization. We are a team of attorney and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who interact with survivors. We do this by facilitating trainings, answering calls on our action line, and we do lots of trainings. Some examples of the trainings we do are the annual new laws that we do throughout the state of Minnesota, the monthly webinars for advocates, and we also do trainings by request. So a little bit about our action line. We answer that Monday to Friday, 9 a.m. to 4 p.m. And we invite all advocates, systems professionals, and even survivors to call us if you have legal questions or just need some information and resources. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, and we also listen and help callers identify possible options and next steps. So we're here to assist you, so please reach out to us when you need to. So on the webinar with me today is Rachel, and Rachel, do you want to do a brief introduction?
Sure. So thank you, Ty. As she said, my name is Rachel Kohler. I'm one of the staff attorneys at Standpoint. My specialty is in immigration law, and I'm doing my Immigration Advocacy 201 today. I'm going to talk a little bit more about what I'm going to talk about today, but it was about 2 years ago now that I did my Immigration Advocacy 101. So I'm going to talk a little bit about some of the information is going to be some review, but I'm also going to refer back to the 101. And so Ty, I think, is going to throw up some links that will be helpful for you to refer back to that training when we get to it.
Yeah, so I will be putting up the link to our Dropbox that's going to have this PowerPoint, that's also going to have some other handouts that Rachel's going to be referencing for all of you. And also I'll include the link to the webinar Immigration Advocacy 101.
Great. Oh, and just a reminder for everybody, these presentations, like all of Standpoint's webinar presentations, are recorded, and we will be putting it on our YouTube page at some point after the recording is done. We're doing it through Zoom now for the first time, and so we found that we're having to share materials through Dropbox rather than through email. So if you want to train using this webinar in the future, I recommend saving down the materials or contacting Ty or I in the future, and we can send them out to you if you need them.
Yeah, so I am actually right now gonna get the link, and I'm gonna put that into the chat box so all of you can see that and pull up the PowerPoint that Rachel is going to be doing. But before I do that, I do have a couple of poll questions that that I'm gonna allow you all to answer, and I'm gonna launch it right now.
Ooh.
Okay, so there's 3 questions. The first one is, how many staff are in your organization? And just click 1. And the second question is, how long have you been at your organization? And the third question is, have you served immigrant survivors? So I will leave that up for a couple more seconds, and then I'll end it and we can share the results.
I did it too, Ty, so hopefully that doesn't skew our overall results.
Yeah. Nope, it should be fine. I mean, I am not doing it. I'm just letting our participants.
Oh, okay.
It's okay. All right, so I'm going to go ahead and end it because I see that a lot have already voted. And I'll share the results. So yeah, so it looks like a majority of people have more than 20, 10 to 20 staff, and a few have 5 to 10, and lots of people have been in the organization. A majority of you have been there 1 to 5 years, and a majority, all actually have served immigrant survivors. So I'll stop sharing those results and let Rachel continue on, and I'll include the link right now in the chat box, okay?
Okay, thanks, Ty. Okay, so I'm going to go on to just kind of give the overview of what I'm going to be talking about in the webinar today. So like I said, about a couple of years ago, I did an Immigration 101 webinar. That is available on our website on the webinar link and also on our YouTube page, which I believe in a little bit now, Ty will be sharing a link to that presentation in the chat box. But there are
Rachel, I just shared the Dropbox information. So for all of you, look in the chat box. You should see the Dropbox information there. So you can go ahead and click on that, and you'll be able to see our PowerPoint.
Okay, great. Thanks, Ty.
Mm-hmm.
And when you're available or when you're free to, Ty, just throw up the Immigration 101 link as well, just to give people some understanding of what I'm talking about today as it compares to last time. So last time I gave a lot more explanation around immigration terminology. I tend to like to do some immigration terminology training before I jump into this other stuff, but just with the time today, I took out that part. So if you do want some more information around immigration terminology, I want to refer you back to that Immigration 101 webinar. I go through a lot of different terms there. Last time I also went through different application types that are available to survivors who are immigrants. I am going to be reviewing that a little bit today, but I'm going to be reviewing it a lot faster. So if you're sort of left wanting more information about some of these different application types, I would encourage you to go back to that Immigration 101 webinar. I go over it with a lot more detail. So the subject matters that I'm talking about today, first and foremost, I'm going to be talking about the more complex than it has any right to be subject of reading immigration documents, understanding people's status by reading their documents, and being able to provide that information to attorneys or in determining what immigration options are available to that person depending on their status. Then I'm going to, like I said, briefly go through the immigration options for survivors, a couple of different application types that are most likely to come up in the work that you're doing as an advocate. Then go through just some different techniques and ways that advocates can assist in the immigration process. If you have ever worked with an immigration attorney on an immigration application with a survivor, a lot of these will probably be familiar to you. You can also throw up in the chat box some different ideas that you have for how you can advocate for people who are working with immigration attorneys. But this is some ways in which advocates have really assisted me when I've worked on the immigration process with a survivor. And then at the end, I'm going to go through a couple of different creative protective order provisions you could consider when you're working with a survivor who is an immigrant, because there may be special considerations that you have that you wouldn't necessarily have with a non-immigrant survivor. And then lastly, I literally threw in this section yesterday because even this week, Standpoint has been receiving calls around guidance around applying for minor children's US passports. When the other parent, the abusive parent, either won't give consent, has been deported potentially, or can't be found, there's a lot of difficulty in getting US passports when you don't have that other parent's consent. And so some discussion around how advocates can help in that process. Okay. So like I said, first I'm going to get through the reading of the immigration documents section. This is a really important thing to understand how to do, because oftentimes when advocates are giving us a call at Standpoint and telling us that they have a survivor who's an immigrant, they want to know what their options are, they want to know whether or not they're eligible for certain forms of relief. One of the first questions I'm going to ask is, what is their current status? How did they come into this country? Because that's a huge part of applying for immigration relief, is understanding that part of the story. And so it can sometimes be difficult to know how to provide advice when I don't have that information. And so I think it's important for advocates, when reaching out to us and asking for advice, to have an understanding of the client's current situation and how they entered the country. So the first document I'm going to talk about, and I'm sorry that it's a little bit pixelated, I got it from the USCIS website. It gives a pretty good detailed explanation of what each section means, but I want to point out a couple of particular sections. I'm also going to be using the laser pointer tool of this here webinar system, and so we'll see how that goes. So the first piece of information I want to point you to is both the surname and the given name, as well as the client's date of birth. It is important when you're working with a client to be sure that that information is accurate. The further down in the immigration process they get, the harder it is to correct that information. And so if right away we can discover that, you know, the last name is spelled incorrectly or the date of birth has the wrong year and they do want to get that corrected, it's better to do that earlier rather than later. The other piece of information I wanted to point out was the amount of entries in which they can have on this particular visa. So you're going to see that here. Sorry, it's a little blurry.
Rachel,
Oh,
can
yeah.
I just interrupt a second?
Sure.
So for some reason, your computer screen is not showing anymore, and some of the panelists showed me, I mean, some of the attendees are saying they can't see your computer screen. Can you share it
Ah,
again?
I certainly can.
Okay.
Sorry about that, everybody. Is it something that you can see now, Ty?
Yes, I can see it.
All
Okay.
right, sorry about that, everybody. Okay, so as I was saying, the other piece of information I wanted to point out to you was this section right here around entries. And so the M in this particular visa, in this sample visa, says M, and that means that the person can enter and re-enter on this visa multiple times. So that's what the M means. You may have a specific number in there. In fact, it's really common just to see a 1 there, indicating that they can enter on this particular visa 1 time. A lot of visitor visas, like this type of visa, will have an M, meaning they can come in and out using the same visa, not having to necessarily reapply for a new visa every time. The other important piece of information can be found right here, the visa type and class. I'm guaranteed to ask you about what type of visa they came in on, because it can really determine what their status is, whether or not they're out of status, whether or not they're still in status. And this particular visa type is R. What that R means is just that this visa is connected to a regular passport. So that information typically isn't that helpful for us. What you should be looking for is the class type. This set of letters and numbers right here will tell us what kind of visa this is. You do not, and really should not, memorize all the different visa class types. There's too many, it's confusing, but it is helpful if you have that information to provide to an attorney, to provide to me, anyone at Standpoint. It can be helpful in determining what type of visa that is. So this particular person's visa is a B1, B2 visa. That's probably going to be either a tourist visa or like a business travel visa. And the last piece of information I'm going to point out here, which is important information, is right here, the issue date and the expiration date. I want to explain to you what this means and what it doesn't mean. So the issuance date on this visa says April 8th, 2003. That means that this passport was issued on that date. That's the date in which they can enter the United States using this visa, April 8th, 2003. Now, the expiration date, April 7th, 2013, is the last date in which the person can enter the United States on this visa. So it doesn't mean that on April 8th, 2013, all of a sudden they're out of status. They just have to have entered the United States before April 7th, 2013, in order to be able to use that visa. What this doesn't mean is that they can enter the country on April 8th, 2003 and stay in the country for 10 years and be able to leave on April 7th, 2013. It doesn't tell you how long a duration you can remain in the country on this particular visa. This is telling you can enter and re-enter multiple times, right? So a person could come in 2003, they may be allowed to stay for 3 months. So then they leave. Using that same visa, they can come back the next month and stay for however long the duration of stay is authorized during that trip. So this doesn't necessarily tell you how long they're authorized to stay when they come in. It just tells you how many times they can come in on this particular visa and up and until what date. Hopefully that makes sense to people. So when we are trying to figure out how long a person's particular entry allows them to stay in this country, where you will be looking for that information is in the stamp in their passport. And so first, the visa documents are located typically in a person's passport. They're a page or a part of a person's passport. These stamps, anytime someone enters the country validly, they will also be given a stamp in their passport, and it provides us with certain information. Sometimes it's more helpful than others. Sometimes Border Patrol agents fill it out better than others, and I'm going to give you a couple of examples of that here. So a good example of this would be on the left side of the screen, this particular stamp right here. The information that we can see on this stamp tells us that this person entered the country on January 26, 2013. You can see that on the top date there. They entered on a Class B1 visa, so that's that business tourist visa. And they are allowed to remain in the country on this entry until July 25th, 2013. So that July 25th, 2013 date is the date in which they are supposed to leave the country. If they stay until July 26th, 2013, they have gone out of status and they violated the terms of their visa in this particular entry. Another example of a different type of stamp is found in the upper right corner here. The class, so you can see here again, the information that's being provided. They entered the country on June 12th, 2013. The class of visa they entered in on is an F1 visa. That's a student visa. And they're allowed to remain until, and this is a great example of how oftentimes you cannot read what these agents are writing into the passports. But what that is meant to say is D/S, which means duration of status. So for visas that are more long-term, like a student visa, you may not have an exact date in which you need to leave the country because they're allowed to remain in the country for as long as their visa is good and for as long as they're complying with the terms of their visa, so as long as they're still studying. Very likely you will see lots of stamps that have incomplete information. And so if you look in the bottom right corner, there's stamps like this one here. So we can see on this stamp that the person entered the country on June 15th, 2012. Difficult to tell what the class type is, maybe a visa waiver program, I'm honestly not sure. And as you can see, the until date isn't filled out. So that particular stamp doesn't provide us with the information we need to be able to tell them how long their duration of stay is allowed to be. And so if that is the case, and honestly very common that that is the case, there is yet another document that we need to look to see how long their duration of stay is. So that document is called an I-94 document. For those who are a bit more old school, who have been doing this work for a while, pre-2013, they used to use these I-94 documents, which were literally like white pieces of paper that were like 4x3 stapled in the back of somebody's passport that provided the I-94 information. Now, like everything else in the world, they've digitized it, and so this, if they entered past 2013, they're not going to have this paper document anymore. It's all going to be available online. So what you can do if you, again, are using this particular stamp entry and you're wanting to know how long their duration of stay is, it doesn't say, they don't have a paper document. You can go to the U.S. Customs and Border Patrol website. And honestly, what I do is I just Google I-94 lookup or I-94 information, and it's right there. It's on the U.S. Customs and Border Patrol website. If you click on Get I-94 information, the screen that you see on the upper left corner is what's going to pop up. And again, I'm sorry, I know it's very small for you, so I'm going to give you a little bit of the information that's on here. So in order to get the I-94 information, you would have to supply them with the last name, the first name, the date of birth, the passport number, and the country of issuance. With that information, you have enough to be able to pull up the I-94 document. So with that information, it'll pull up what you can see here in the lower left side of your screen. This is what the digitized I-94 document looks like. So you'll have your I-94 number there up top, and then right below it, you're going to get that admit until date. So we can see here that this person entered, and sorry if you can't see if it's too small, but on the screen it states that they entered on April 11th, 2012 on a B1 visa. And then they have this admit until date here of October 10th, 2012, indicating that they came in April and they're allowed to stay for 6 months on this particular visa before they have to depart. The reason this is good information to know is because if they've overstayed a visa, it doesn't necessarily mean they can't apply for immigration relief, but it does mean that if they've overstayed their visa, they've likely fallen out of status. Okay, so now I'm going to be talking about the permanent resident document, also known as the green card. The important information on this document, if you're working with somebody who has a green card, is right here is the USCIS number information. This is also known, probably more commonly known, as the alien registration number or the A number. Anybody who's applied for any kind of immigration relief or has had really any contact with immigration is going to have a USCIS number or an alien registration number assigned to them. This is kind of like a social security number. It's like their identity number. And anything that they filed with immigration, if you're going to look up that information, if you're going to FOIA request a file, anything, you're going to need to use that USCIS number or that alien registration number. So that's a really important number to know. Again, always good to check the given name, the surname, and the date of birth, making sure that that information is correct. Another important piece of information on this document is the category. Again, this can be helpful for me when you're providing me with information wanting to know what relief options the survivor is eligible for. I may want to know what kind of green card they had or how they got their green card. Again, it's going to be like a lot of codes and numbers that I'm not recommending anybody memorize. I have to look it up every time to make sure that I know which category code references what. But just good to know where that is so that you can supply, me with that information when you're asking questions. So category RE8 stands for the child of a refugee. So I can tell that Test W specimen got her green card because a parent of hers was a refugee. And then the last important piece of information that I'm going to point out on this document is the residence since and the card expiration date. And the reason why this is important and how it's going to come up in the course of your work is because I'm going to be asking, if you say a client has a green card, I'm going to be asking, is it a permanent green card or is it a conditional green card? And the way to tell that is either to look at that category code or to look at how long the green card is good for. So for permanent green cards that are not conditional on anything, they're going to be valid for 10 years. So Test W specimen here has a 10-year green card. She was a resident since August 21st, 2007. Her card doesn't expire until August 21st, 2017. So I can tell just from that she has a non-conditional green card and there's no concerns about whether or not she separates from her abuser, who may have been the person who got her green card. A conditional green card that you're most likely to see are green cards that are conditioned on marriage. So if you got married and the marriage is relatively young, or you've been married for less than 3 years, when you get your green card, it's going to be conditioned on that marriage. So if I get my green card based on marriage to a US citizen or green card holder, we're going to have to provide all of this evidence to immigration that we got married in good faith. I didn't just marry him to get a green card. And then they're going to give me a conditional green card saying, yeah, you can have this green card, but it's conditioned on that marital relationship. And those green cards are only going to be valid for 2 years. And that's because in 2 years, immigration wants us to resubmit evidence proving again that our relationship is still legitimate, so that we didn't just get married to get that green card. And then at that point in time, if immigration looks at everything we've supplied and they're like, okay, we believe you, you guys are in a real valid marriage, I'm going to remove the marital conditions on your green card and supply you with a permanent 10-year green card. So obviously, if you folks are working with a survivor who has a green card and that green card is conditioned on marriage, that's something that needs to be addressed with an immigration attorney. And I'm going to talk about that a little bit more later. But that's why it's important to know, looking at this resident since card expiration date, whether or not it is a 10-year or a 2-year green card. Okay, so the next document I'm going to be talking about is the employment authorization document, also known as the work permit. It has a lot of the same information as the green card, so I'm not going to go over everything again. But whether or not a work permit document is able to be renewed, so as you can see, although I think there's a typo, it was supposed to be valid since 1/1/2008 until 5/10/2011. But how these work permit cards, just like the permanent resident cards, are not permanent documents. They do either need to be renewed or you need to file a new application. And so it's important to know how this person got the work permit and whether or not it's something that can be renewed. Some work permits can be renewed. Some, depending on how you got it, can only be renewed a certain number of times, or after it's done, it's done. And so the way to tell how or what kind of work permit this is to, again, look at that category code. And so this particular person has category code C09. I had to look it up. What it means is that Test V specimen got their work permit card through an application for a green card. So when you apply for a green card, you can also apply for a work permit document. That's what this particular person did, and that's how he got his work permit. So that's kind of how you connect the two things. Once the work authorization card expires, this person is no longer has proof necessarily that they have authorization to work. Depending on the circumstance, this Test V specimen could also use his green card as authorization to work. But let's say it's someone who has DACA status or deferred action status. They will need to have a valid employment authorization card to prove that they are eligible to work. Whereas a big difference between the work permit document and the green card is if your green card expires and it's not a conditional green card, it's one of those permanent green cards, it doesn't necessarily mean you no longer have status. It just means you no longer have the ability to prove that you have status, which can also be very important. So when you're working with a survivor, it is important to look at that expiration date and make sure that renewal applications are being submitted before the expiration date hits. Okay, Ty, is there any questions about documents?
No questions yet, Rachel. And if you do, I did throw this up on chat, but if you have a question, there is a question and answer tab on the bottom of your screen. You can type in your question there. Otherwise, you can also type your question in chat. I will check that as well and share it with Rachel.
Okay. And just know that having that information, reading those documents, being able to provide that information to an attorney can be very helpful. Also good, if you forget any of this stuff, you can always call and ask me, what does this code mean? Where should I be looking? I'm happy to talk you through that. Okay, so that brings us to the next section. I'm going to try to talk pretty briefly about the different immigration relief options. Again, I went through it in more detail in the Immigration 101, so if you're not getting enough information here today, please refer back to that. I just want to make sure we can get to everything. I could also talk about this stuff for forever, so I'm trying to limit myself to how much I can say about each of these things. So some of the common immigration relief options for survivors who've experienced domestic or sexual violence are listed here. I'm going to talk about the first 4 application types today. I'm not going to talk about asylum or special immigrant juvenile status today. So I kind of wanted to give you just a brief understanding of what those 2 things mean. So asylum is eligible for people who've come into this country who are unable or unwilling to return to their country of nationality because of a well-founded fear of persecution, and that persecution, that the harm that they fear that they will experience if they return back to their home country, is based on their race, religion, nationality, political opinion, or membership in a particular social group. Some of the kickers with asylum is that asylum typically needs to be filed for within 1 year of entering the United States. There are some exceptions to that, but that's the general rule. So if you believe that there is someone you're working with who may be eligible for asylum, it's good to get them in contact with an immigration attorney as soon as possible. Another application type is special immigrant juvenile status, or SIJS, SIJs. And these are available to undocumented immigrants who are under the age of 21. So in the immigration context, children or minors are typically under the age of 21, not under the age of 18. So if they're under the age of 21 and they have been abused, abandoned, or neglected by one or both parents, they may be able to apply for special immigrant juvenile status, which eventually will give them the ability to apply for a green card. It requires both district court action, typically through a family law action, and immigration action. And so it's a more complicated process than some of the other things I'm going to talk about today. So if you believe that you're working with a minor, someone who's under 21 who might be eligible for special immigrant juvenile status, absolutely get them in contact with an immigration attorney, maybe even a family law attorney to help with that process. But like I said, the 4 application types that I'm going to talk about in a little bit more detail today will be the U visa, T visa, Vow Assault Petition, and the removal of conditions with the abuse waiver. Okay, so here is a fact scenario that you could come up with that would make a person eligible for a certain kind of immigration relief. So I'm working with a survivor who does not have lawful status and they've been a victim of a crime. What are their legal options? So that kind of brings us to our broadest application type called a U non-immigrant status, or a U visa. This is the application type people are probably most familiar with, and certainly ones that the survivors who are immigrants that you're working with are probably going to have heard of U visas. So to be eligible for a U visa, you must be in non-immigrant status, which means you don't have a green card, and you are a victim of a certain crime, and you have suffered mental or physical abuse and are helpful to law enforcement or government officials in the investigation or prosecution of the criminal activity. So when I say that they must have been victims of certain crimes, this includes a long list of crimes. In the documents that Ty provided you in the Dropbox, one of the documents that I have is a comparison chart. This is a chart that compares U visas, T visas, Vow Assault petitions, and the removal of conditions, all the applications I'm going to be talking about today. It kind of compares them side by side and goes through some of the most common questions, such as who is eligible, what forms do I file, how long does this take, can I include family members? So some of the things I'm not going to have time to address today may be, you may be able to see on that comparison chart. One of the pieces of information I have in that chart is, what do I mean by victims of certain crimes? What certain crimes are you talking about? So it includes a long list of crimes, but some of the particular crimes you're most likely to see are abusive sexual contact, domestic violence, felonious assault, involuntary servitude, prostitution, rape, sexual assault, sexual exploitation, stalking, human trafficking. A lot of the different crimes that that your clients may be experiencing are likely to be eligible for a U visa. So they need to have been a victim of one of those specific listed crimes, have suffered mental or physical abuse as a result, and so proving abuse, providing information about abuse is part of the U visa process. And the real important part is that they have been helpful to law enforcement or government officials in the investigation or prosecution of the criminal activity. And the reason why that's a really important part of the U visa application is because it, number one, requires reporting. So you cannot file for a U visa if you've not ever reported the crime. Not only does it require reporting, but it also requires a certification form be filled out by that law enforcement or government official, which says, yes, this person is a victim of this crime, and they have been helpful in the prosecution or investigation of the case. So under risks there, you'll see I put requires certification. Depending on the agency you're working with, you may have an agency that's really great about filling out U visa certification forms, and some aren't. And so unfortunately, where the crime occurs can really make a big difference in whether or not a person can apply for a U visa, because they need to get that certification. If you do apply for a U visa and it gets approved, what it can give you is 4 years of legal status, basically protection from removal for 4 years. Once a person gets put on the wait list or after approval, it provides the applicant with work authorization, that work permit document. It allows them to apply for certain family members to be able to come in the country or get that same status if they've already entered the country and are living with you. And after you've held the U visa for 3 years, you can apply for a green card. You'll also see I put on there that it has a generous waiver. So what that means is if you have a criminal violation or an immigration violation, and you're applying for an immigration benefit, sometimes that can prevent you from being eligible for that benefit because you have this violation or this criminal infraction in your history. For U visas, you can ask for that to be waived, and U visa applications are really generous with their waivers. And so there's not a lot of criminal or immigration violation activity that a person can have committed where it would prevent me necessarily from applying for the U visa. However, there are risks, and for U visas, there are quite a few kind of downsides to applying for the U visa. The big downside is just how long the processing time is. So it's currently taking 8 to 10 years to get a final decision on a U visa. And that's a ridiculously long period of time. You may be able to get on the wait list, which basically is immigration telling you they think everything looks approvable, but an immigration visa, U visa, is not available at this time. So we're going to put you on a wait list, which allows you to apply for a work document. That is taking about 4 or 5 years. So that's not even a quick process, getting put on the wait list. While the application is pending, even if you're on the wait list, that's not necessarily it does not necessarily provide the survivor with any protection from deportation. So if you have a pending U visa application and you have a negative interaction with ICE, they put you in removal proceedings, they could deport you back to your home country even though you have a U visa pending. Once you get a U visa approved, some immigration applications that will provide you with access to a lot of public benefits, a lot of different services. For U visas, it's very minimal what it actually gives you access to. And then lastly, there has been a recent policy under our current administration which says if you're applying for these kinds of applications and your application is ultimately denied, they can issue a notice to appear in court and start deportation proceedings against you. Now, that hasn't been put in statute or put in law, but it is current policy under our current administration. And so if we have a change in leadership, that's something that could change in the future. But for right now, this is what we have to be informing people about. If the U visa is denied, it could result in possible deportation. That was really quick, and I know U visas are common. Is there any questions from that, Ty?
No questions yet.
Okay, great. Another fact scenario, I'm working with a survivor who doesn't have lawful status and they've been a victim of human trafficking, including both sex and labor trafficking. What are their legal options? Okay, so now we have the T non-immigrant status, or the T visa. That is for obtaining non-immigrant status for victims of human trafficking who have complied with reasonable requests for assistance or investigation, or in the investigation or prosecution of the human trafficking, and would suffer hardship if deported. So there are a lot of similarities between the T visa and the U visa, but there are some really important differences. The obvious major difference is the U visa includes a much broader array of different crimes that the person could have experienced in order to be eligible for a U visa. For a T visa, it is solely restricted to people who've experienced human trafficking. Again, both sex and labor trafficking, you can apply for a T visa. Like the U visa, it requires reporting. As you can see under the benefits tab, it does not require the certification form, however. So U visas, not only do you have to report the crime, but you have to get law enforcement or prosecutors or other government officials to sign the certification document. For T visas, you just have to be able to provide proof that it has been reported. So you don't necessarily have to get that certification. There is a certification form, but you don't have to get it to apply for a T visa. Also, if you are working with a minor, so again, in immigration, that means someone under the age of 21, and they've experienced trafficking, they don't have to report. Anyone who's over the age of 21, however, it does require reporting. If you get a T visa approved, what it provides you, like with the U visa, is 4 years of lawful status. You can apply for a green card after 3 years, or importantly, as soon as the investigation is closed, so it could be faster than 3 years. Like the U visa, it provides work authorization. But unlike the U visa, the processing time is significantly faster. So U visas are taking 8 to 10 years to get final determinations. T visas are taking about 1.5 to 2 years, which has slowed down quite a bit in the last couple of years, but still much faster than the U visa. Also, unlike the U visa, if you get a T visa, you are eligible for many more public benefits. If you've ever worked with someone who has refugee status and all the benefits that come with having refugee status, T visa holders get the same benefits as folks who come in as refugees. So there's a lot more public benefits available to T visa holders. Oh, I probably should go over some of the risks. So some of the risks. First, you have to report. Going through the process of filing a T visa, like any of these different processes, may involve some re-traumatization. It's requiring a person to, in detail, provide information about some of the worst experiences of their lives. This is why it's really important for me as an immigration attorney to be working in tandem with you advocates and other mental health professionals to make sure that a person isn't being without supportive services during this process. And then like the U visa, if it is denied under the current policy, the person could be ordered removed, or at least put in removal proceedings to attempt to have them removed to their home country. Any questions after that, Ty?
No.
Thank you. Every time I ask, it gives me like a minute to drink some water. So I'm just asking.
Yeah.
Okay. So what if you're working with a survivor who's married to an abuser who has citizenship or holds a green card, yet the survivor is still undocumented? So right away, that should be a red flag. Because if an immigrant is marrying someone with status, with a citizenship or with a green card, that spouse should be applying for them to get status as well. So if they're not, there is likely something underlying that. Oftentimes, those people are experiencing abuse. And so a potential form of relief would be through the Vow Assault Petition. Vow Assault petitions are, so typically, in a situation where we're not dealing with abuse, if you marry someone who has status, what they will do is they will petition for you. They will ask for the government to allow you to either come into this country or stay in this country without the fear of being removed, to eventually allow you to apply for a green card, apply for citizenship. So your spouse who has status can petition for you. They're kind of like your anchor in this country. If you don't have them petition for you before the Vow Assault Petition, there wasn't really an option. You'd have to return to your country of origin. However, through the Vow Assault Petition, a survivor can self-petition. They can petition for themselves to get immigration status without necessarily relying on that abusive spouse. I'm saying spouse because that's what you're most likely to see in the course of the work that you're doing as advocates. But Vow Assault petitions can also apply to abuse or folks who have experienced abuse from their parents or their children. Also important to note that while VAWA comes from the Violence Against Women Act, it can apply to men and women equally. Part of the benefit of a Vow Assault petition, so through the Vow Assault petition process, you're going to have to prove, or your client is going to have to prove that they got married in good faith. That's always a concern of immigration. They'll have to provide evidence of a good faith relationship with their abusive partner. And they'll also have to provide evidence of the abuse. Variety of different ways to do that. I talk about that a lot more in the Immigration 101. Some of the benefits to applying for a Vow Assault petition: if you get a self-petition approved, you'll have what they call deferred action status. It basically provides you with protection from removal. It provides you with legal status while you are in VAWA status, which, as I put here, is renewable. It may have an expiration date on it, but you're able to renew that. Also, depending on the relationship to the abuser, you may be able to apply for a green card very quickly after getting a VAWA approval. So if I am married to a United States citizen, I can apply for the green card at the same time as I apply for the Vow Assault Petition. However, if my partner has a green card, doesn't necessarily have citizenship yet, I may have to wait a little bit of time before I can apply for the green card. But the Vow Assault Petition often will lead into applying for a green card. The last benefit I wanted to cover is that you can apply for minor children at the same time, and actually it's the same exact application. I can include the child's information on my Vow Assault Petition. I don't have to file a separate petition for them. Some of the risks of a Vow Assault Petition. So unlike the U visa and the T visa, where that waiver of any criminal or immigration violation is really generous, it's less generous when we're talking in the context of a Vow Assault Petition. So if the survivor has some particular criminal infraction or immigration violation, that's something that they'll have to consider and talk about with their immigration attorney. It also requires that specific relationship to the abuser. So I've had a lot of people call where they say that they're in this marital relationship, the person has been abusive, but the marriage was only in the cultural context. It wasn't necessarily a legal marriage. Unfortunately, for Vow Assault Petition, it has to be a legal marriage in order for the person to be eligible for a VAWA. So it has to be a legal marriage, and the marriage has to be to someone who has status, to someone who has a green card or someone who has citizenship. And then again, like all of the other processes I've been talking about, U visas and T visas, if the Vow Assault Petition is denied, that could result in referral to immigration court. The Vow Assault Petition right now, and I in the Dropbox, I have timelines for each of the processes I'm talking about today that give you kind of more specifics around all the different steps and what the process looks like. But it also tells you how long the process is likely to take. So I think Vow Assault petitions are taking about 1.5 years to 2 years right now. So the last situation I wanted to cover, and I'm sorry, Ty, is there any questions?
No questions, Rachel.
Must be explaining it so well. Okay, so the last scenario is a survivor is married to an abusive US citizen or green card holder. They have a green card, but it's that conditional green card I was talking about before. That green card is based on their marriage. They want to separate from their spouse due to the abuse. What are their options? So if you're working with a survivor, they say they have a green card, you look at the green card, you see it's only valid for 2 years, that person is still going to need to remove the conditions on their green card, and there is an option to remove those conditions without relying on the support of their abusive spouse. And you can do that through an abuse waiver. So in a non-abusive situation, what people would do is before the expiration of the green card after 2 years, they would apply jointly with their partner, proving again to immigration they're in a good faith marital relationship. They provide all the evidence of the vacations they've went on, the cards that they've sent to each other, pictures of visiting each other's family, tax returns they filed together, kids they might have had within those 2 years to prove that that relationship is real. And they file that together jointly. However, when you're applying for a waiver of the joint filing requirement, you'll have to prove that the person has experienced abuse or extreme hardship. And so, like the VAWA, it's a lot of the same ways that you would evidence abuse. You could supply police reports, letters from advocacy, shelter records, videos, pictures, hospital records, protective orders, lots of different ways to prove abuse. So once that application is filed, if they have a conditional green card that's set to expire, that conditional status will be extended. So they won't necessarily fall out of status. If they are approved for the removal of conditions with the abuse waiver, they're going to receive a 10-year green card that is no longer conditioned on that marriage. So now they're going to have a permanent 10-year green card that is in no way connected to their marriage to that abusive person. Some of the downsides to applying for this is, like the VAWA, it requires that they have a green card based on marriage to someone with status. Also, it's likely to pull an interview with immigration. So again, another reason why it's important to be applying for these things with an attorney so they can attend the interview with you. Like the Vow Assault Petition, it has a less generous waiver. So if there is criminal violations, that's going to be taken a little more seriously in this context. And then, so this is a little bit different than the other applications I've been talking about. All other applications where if the application is denied, they could be referred to immigration court for deportation proceedings. This particular application type will always, it is in law that if it is denied, they will be referred to immigration court. This is not just policy, this is something that is part and parcel of this particular process. So that's another reason why it's really important to start considering these things, gathering documents, working with an attorney.
Rachel, I
Yeah.
also want to add that the interview with immigration, I know you had mentioned that having an attorney being present is needed, but as an advocate, you can also attend as well with the
Yeah.
client.
Yeah. And I mean, it's always, I think, good in a lot of these processes to have an attorney, but we all know that that sometimes doesn't happen, or maybe the attorney relationship ends before the interview happens. So that's certainly something that advocates can do. You're absolutely right. Attend that interview.
Mm-hmm.
Okay. Any questions after that, Ty?
No.
Okay.
Actually, yeah. I'm sorry.
That's okay.
There is a question. Okay, so the question is, what if the immigrant survivor does not have a green card yet, has a work permit? Can she get divorced?
So I guess I would have more questions to follow up. When you say don't have their green card yet, do you mean that they've applied for the green card, they just haven't received it? Also wondering, how did they get that work permit? What is that work permit connected to?
Okay.
Because typically, if you don't have a green card yet, you don't have a conditional green card, and so you may end up having to apply for a Vow Assault Petition rather than a removal of conditions. So if they never got a green card, if their spouse never applied for them to get a green card, but their spouse has status, then a Vow Assault Petition is actually a better option.
So in a scenario would be they've applied for the green card but haven't received it yet.
I mean, I would wonder where they were at in that process. Are they just waiting for the green card in the mail? Do they still have to supply certain paperwork? They're not done with the process. If they're just waiting for it in the mail, then it's hopefully something that can be delivered and may be able to remove conditions after that. But if they're at the beginning of the process, they aren't going to receive it without additional work on that green card application, then I think it's probably better to file a Vow Assault Petition. That's a really...
Well, she has a VAWA right now, a VAWA.
She has a Vow Assault Petition?
Yes, she does.
If she has VAWA approval and she's waiting to get that green card, yes, you can divorce. So you can divorce and still apply for a Vow Assault Petition if you apply for it within, and I should have that information in front of me. I want to say if it's within 2 years. I would want to double check that, but you don't necessarily have to still be married in order to apply for a Vow Assault Petition. So especially if they're in the process of applying for a VAWA or they've already received VAWA status, they can absolutely get divorced. That has no effect on their application.
Okay, well, thank you. And for specific type questions like this, Rachel is in the office every day, Monday to Friday, 9 to 4. If she is out of the office, we will take messages. She'll call you back. So, call our office.
Yeah, these are really good questions, and the nuances can get really particular. So please absolutely give me a call and we'll talk it through and figure it out.
Okay.
Okay, so as that one person who was just asking those wonderful questions, what is the advocate's role in an immigration process if they are working with an attorney? And so, Ty, if you have anything you want to add to any of these, feel free to jump in. Otherwise, I have a couple of recommendations here. First, like any advocate relationship with their clients, achieving and maintaining safety and stability is very important. Particularly, I think immigration attorneys can sometimes have blinders around, okay, we need to start working on the immigration application, gathering documents, but really it's hard to work on an immigration application if you don't have a home to stay in, if you don't have food to put on the table. And so working with an advocate to at least get some amount of stability really can help with now, again, looking forward to the immigration process. Providing safety plans, obviously keep immigration-related safety concerns in mind, particularly around what happens if I get removed, what happens if my abuser get removed, what will happen with my kids. There's a lot of safety planning documents around there about safety planning around in the immigration context. And if you have any or want any specific information about that, I can provide that for you. Reporting, a lot of the application types I've been talking about requires reporting to law enforcement or investigators. And so being able to accompany survivors to wherever they're reporting can be very helpful. Accompanying to hearings if there is a criminal hearing or protective order hearings in conjunction with the process. Helping to coordinate language access can be huge, providing interpreters or translators in order to help the survivor. Providing transportation assistance can be very helpful. Most immigration attorneys are going to require the client to come to their office, so being able to provide them, maybe not with transportation yourself, but provide them with information about bus routes or Lyft or Uber options. Connection to, what I mean by connection to opportunities is a lot of the applications I was talking about before are going to require some level of proving to immigration that the applicant is a good person who has been trying to heal from what they have experienced and become good members of society, people that we want to give immigration status to who can contribute to society. And so different ways of proving that can be proving that they're going to job trainings, that they're going to get their GED or learn English, that they've been taking advantage of therapy or counseling services are just some examples. If you have identified that this person may be eligible for immigration relief, always a good idea to help with a referral to an attorney. Also really helpful to help in that attorney-client relationship. I know I've talked a lot about this with the advocates around our office. A lot of the applications that I work on, I'm working alongside an advocate, and it can be extremely helpful, both for me, for the survivor, for making sure that things move along smoothly, that all the information is being provided. I know sometimes, and I don't think I'm a very intimidating person, but the fact of the matter is when a survivor is meeting with me, they may be intimidated by the fact that I'm an attorney. They don't know me. I haven't necessarily built up the same level of trust that an advocate may have with a client. And so it is helpful when I'm talking to a client, if I'm saying, do you understand everything? Are you comfortable with this? They're telling me, yes, 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 it's fine. But then outside of the attorney's office, they're talking to their advocate about how, I didn't understand that. What the attorney said here really confused me. I'm really uncomfortable with this. Being able to help your client advocate for what they want with the attorney can be really important because it sometimes is really difficult for the survivor to do with their attorney. Also help the client, certain attorneys may want the client to complete their own affidavit or their own declaration talking about the abuse they've experienced. I think different attorneys handle the writing of the affidavit differently. So every one of the applications I talked about, the U visa, the T visa, the VAWA, they all require detailed affidavits going through the details of the harm that they have suffered. And so those affidavits can be very difficult to write. Sometimes attorneys prefer to have clients try and write the affidavit on their own first. I think partially because writing affidavits is very time consuming, and so not all attorneys are able or willing to take the time to write the affidavit with the client. Sometimes they think it's stronger if it comes directly from the client. I can tell you my personal way of doing it typically is a combination. I may ask the client if they would prefer to write some of it out before they meet with me, empower them to do that if that's something they want to do. But more often than not, They're meeting with me 2 or 3 times, talking to me. I'm writing notes. I'm drafting the language and reviewing it with the client. But if the client is being asked to write some of the affidavit on their own, it can be really helpful as an advocate to help them with that process.
And I know, Rachel, I've experienced both when I was
Yeah,
doing advocacy with clients. So, some attorneys will prefer to write it, but then a lot of the attorneys, though, that I've worked with wanted the client to write their own affidavits. And
yeah,
so, as an advocate, helping your client do that, because a lot of times the people that we're working with, their fluency in English is not that well, or sometimes I've even had clients write their affidavit in their native language
hmm,
and got it translated out.
right.
Mhm.
Yeah, and I think you're absolutely right. It's really dependent on the attorney, and I know that attorneys feel differently about what's better and what's not. So you're likely, if you're doing a lot of this work, to run into attorneys that prefer they do it, or attorneys that prefer that the attorney draft it. So it's dependent.
Mhm.
Also, and when you're meeting with an immigration attorney, there's going to be to-do lists and appointments to keep track of, but especially if they're also involved in going to court for protective orders, maybe they're involved in child protection, maybe they're involved in a criminal action. There could be a lot of appointments in their head that they have to keep track of. So it can be really helpful to have advocates help them track their appointments so that they don't miss things. And I know that after meetings that I have with clients, I'm always giving them to-do lists, things to, start gathering documents to apply for. And so to be able to help them keep track of to-do lists, make sure that they're getting the information they need for the next appointment can help make the process go a lot smoother.
Yeah, and definitely depending upon the client that you're serving as well. As the advocate, you'll know how much hands-on your client's going to need. So
Hmm.
I've had clients that were super great about keeping on track of everything, and I would just kind of say, oh, remember we're meeting on this and that date, and that is basically all that I would have to do. But there are
Hmm.
some clients that I've worked with that has been super overwhelmed with the process.
Hmm.
Court proceedings, gathering documents and evidence, and then trying to trying to deal with all of that, and also figuring out expenses and financial things and all that. It could become really overwhelming. So having an advocate kind of like help in, we always want to empower our clients, right? We want to empower them to be able to do things for themselves. But
Hmm.
sometimes if as an advocate, you notice that things are getting overwhelming and your clients are needing a little bit more hands-on, like
Hmm.
in these types of cases, I see it more often.
Well, and I mean, that makes a lot of sense too, because if you think about it, this legal process, this system, it may be unfamiliar to them if they haven't been in the country that long or they haven't necessarily had experiences with these systems.
Oh, for sure. I mean, even if you've been in this country,
Oh,
it's
for yeah.
confusing. And
Oh my
so
God.
first time doing it and going in, and it's nerve-wracking, like meeting with immigration agents and meeting with law enforcement officers and meeting
Hmm.
with attorneys, like all of those things are very, very intimidating,
Mm,
especially if, immigrants have come from countries where law enforcement agents and things, those aren't the type of people you really want to be meeting with and running into, because you don't
mhm,
have much control or power in what happens after you meet with them. So, you know, it it is it's tough.
mhm. Yeah, I agree completely. Thanks, Ty. Which gets to the last point there. It can be overwhelming to get those two to-do lists and your attorney asking you to gather all of these documents. That can feel very overwhelming and sometimes be time consuming because they may have to apply for a copy of their birth record or apply for a passport. And so being able to help them gather these documents and then in some cases apply for them, getting copies of police reports, I know is always a fun experience that advocates can really help with. And then the last point on there is providing support letters. I'm always very happy to talk with advocates who are working on providing support letters for clients that are applying for immigration applications, because getting a support letter from an advocate, especially if the immigration application is related to the abuse, can be extraordinarily helpful. And sometimes it can be difficult to know how much information to provide in those support letters. And so I'm always happy to talk over how much or how little information should be put in these letters. Obviously, making sure that we're always getting consent from the survivor when you're writing those letters. Anything you want to add to that, Ty?
Um, well, I'll just add that as far as that last part where Rachel was talking about gathering of documentations and things like that, evidence, a lot of times your clients aren't going to know, what's going to be helpful and what's not going to be helpful in their immigration case. And so as an advocate, just being aware that, you might need to be mentioning like, oh, do you have any photos of, the times that you were together? Do you have any cards that, your partner might have mailed to you or sent to you when you were in the courtship phase? I mean, just asking them specifically for specific documents instead of just saying, do you have any evidence or do you have anything that you can, document that your relationship is, valid and you did marry in good faith and things like that. Like just asking those specific terms can be confusing because what are you looking for, so asking specifically for, do you have any photos together, do you have any photos of your wedding day or your engagement photo, things like that, like asking for specific documents can be very helpful.
And helping them to kind of determine that. Like I have on there evidence of abuse, depending on the client, there could be very different kinds of evidence you can use to support that allegation of the abuse. And so advocates can be really helpful in brainstorming what potential form or evidence that you can use to provide evidence of the abuse or evidence of the good faith marriage.
And as far as support letters go too, I mean, a lot of times immigrant clients will find it very difficult to get support letters from other people other than advocacy. So like people that have witnessed the abuse and things like that, like they're going to be kind of hesitant to write some of those support letters and stuff. And so as an advocate, being available to explain to potential people that can write those affidavits in support of your client, like, if they're worried about any risk or any concerns that they have, like, be available and ready to talk them through all of that.
Oh, absolutely. Yeah. Even as you're talking about it now, I'm just like, thank God that on many of my cases, they're also working with an advocate because advocates can really make this process go a lot better for everyone involved as long as you're working with the attorney and kind of going through all these things. It can be extraordinarily helpful.
Yeah, and it is a longer process and it's a lot of detail-oriented things. And so as an advocate, if you have any questions while you're going through providing assistance to any of your clients in doing these, like that's what I'm here for. I'm an advocate support program manager, so that is specifically my role. I've done these on the phone with lots of advocates and talking about, best ways to support, how to draft things up, how to write things, how to word things, like that's what I do. If you have questions, please give us a call.
Yep, I second. Okay, so it actually kind of talking about the different documents that you can be gathering and keeping in mind the different documents you might need for these immigration applications sort of brings us into immigrant survivors and specific consideration in protective orders. I'll get to that in a little bit. But I want to start by talking about just particular considerations in the immigration context when you're talking about protective orders. So that first point where it says protective orders can be particularly effective if the abuser is a non-citizen. The reason why that is if you get a protective order, as I'm sure everybody on this webinar knows, a protective order is not just having a protective order is not a criminal infraction. However, if you violate a protective order, that is a criminal action, and it's a criminal action that is taken seriously in the immigration context. So an issuance of a protective order alone has no immigration consequences for either party, but if a person violates a protective order and that is a criminal action, that could have some very serious consequences as to their immigration status. So if the abuser is a non-citizen, violating that protective order could have really dire consequences for them. And so this can kind of be a double-edged sword. It makes the protective order, it really gives that protective order teeth, but also I think we all know that there are circumstances in which A petitioner of a protective order may want the abuse to stop, but they don't necessarily want the respondent to be deported. And so I've seen it kind of work both ways, both that it is particularly effective on the abuser, but also it can be ineffective in that the survivor doesn't want that person to be deported, and so they're less likely to report violations. And so just something to consider. Having protective orders in all the immigration applications I talked about can provide evidence of abuse in those immigration applications. So when I'm filing a Vow Assault Petition and I want to prove abuse, I can attach that protective order to that application. And then like anything, survivors, in particular immigrant survivors, may have a distrust of the legal system and be less likely to file protective orders. For some survivors that you're working with who aren't from the United States, they may have lived in countries where abuse of women, especially when you're talking in the context of a marriage, was not taken seriously. And so for that reason, they may have learned not to expect justice from those legal systems. And I will guarantee you that abusers have reinforced those beliefs. Abusers have told them, if you call police, they're not going to believe you. If you go to court, they're not going to listen to you. They're going to listen to me over listening to you. I'm a citizen. And so those are just vulnerabilities that abusers sometimes know to pick at. So it could be particularly important when you're talking about getting a protective order to educate the client on the process and the pros and cons to applying for a protective order. Okay, so now I want to talk a little bit about the importance of economic relief before I go through some of the, kind of more creative provisions you could consider putting in an immigration or putting in a protective order petition. And the reason why I want to do this is because economic relief can be very important when you're talking about an immigrant survivor. The nature of what it says, family-based immigration processes. So what I mean by that is, if the abuser is the reason that this person has been petitioned for, maybe they came in, maybe their abuser is here on a work visa and they're here as dependents on that visa. So their status is literally dependent on their relationship with their abuser. They may not be able to work, so they're really like heavily dependent on that relationship and the financial support of that abuser. Or maybe they don't have status, and so they have no, work authorization document. They have no ability to find gainful employment on their own, so they are really dependent on that abuser to help support them. They could be really vulnerable to economic abuse. And so when you're filing protective orders, requesting child support and maintenance in those petitions could be all the more important when you're talking about survivors who are immigrants. I also want to talk a little bit about the affidavit of support. Ty actually was telling me about a case she was working on where the affidavit of support came into play. So what the affidavit of support is, when a family member who is either a U.S. citizen or has a green card, and when they're petitioning for their family member, their spouse, to come into this country, they will sign what is called an affidavit of support on Form I-864, where they are promising to financially support this other family member. They're promising not to allow them to drop below 125% of the federal poverty guidelines, which is not a lot of money, but it is enough to keep them above the poverty level. And so this is a legally enforceable contract between the family member, the citizen or the green card holder, and the federal government and the immigrant who they're sponsoring. And so the reason why it's important to keep the affidavit of support in mind, so if you're working with a survivor that has an affidavit of support with their abuser, number one, it prevents that survivor from being able to apply for public benefits. The whole reason the affidavit of support exists is because they want to provide the federal government with some amount of protection from people coming into this country and applying for public benefits. And so they have this citizen or lawful permanent resident green card holder to promise the federal government, to promise this immigrant who's coming into this country that they're not going to let them ever need to apply for public benefits. So that means that while the affidavit of support is in play, which for most people is around 10 years, the survivor who has an affidavit of support on their behalf cannot apply, will not be eligible for most public benefits. So that's another way that the abuser or the sponsor can kind of continue that economic abuse and that economic coercion, because it's more difficult to leave if you don't have the ability to apply for public relief. So when you are filing protective orders, it can be a really good idea to be requesting the child support and the maintenance, and if an affidavit of support is in play, by using that as an argument to bolster your argument to the judge that child support and maintenance should be ordered in this case, because the abuser has already made a legally enforceable promise that they're going to keep the survivor above the poverty level. And the survivor, for potentially a variety of reasons, they may not have the legal ability to work, really needs that support and that maintenance. Is that kind of a good summation of how it worked for you, Ty?
Yeah, so the situation that I had worked with was her husband did sign an affidavit of support when he was petitioning for her to come to the United States under fiancé visa, and then they got married when she came to the United States. They got married, and then abuse happened, and she filed for an order for protection. And in that order, we did ask for some spousal maintenance, and talking about the reason why she should be eligible for spousal maintenance is because of that affidavit of support, because of the fact that she wouldn't be able to get any state benefits and insurance or anything, medical insurance and things, because he had signed that. And so with that argument, the judge did end up granting it. Which is interesting because it is up to the judge whether they're going to grant that or not. And so for me, when I was doing advocacy, I was doing advocacy in an area that had we had a high diverse population in that community, and so I would regularly, once a quarter, go in and meet with our criminal justice folks, judges, law enforcement and things like that, to build that relationship and also to let them know. And this is the importance of building relationships. Another important piece of work for advocates is building those relationships and also explaining to judges like, hey, so right now what I'm seeing is I'm working with a lot of people from this community, and there's an issue of affidavit of support and things, and just bringing some of these topics up in conversation with your systems folks, so that when you do come up in a situation right now, like, hey, this is what I'm using, it's not the first time that the judge has heard of this, right? You guys have talked about it, it's been in part of conversation, and judges then are more kind of leaning towards signing and granting what your request is, what your client's request is, because they understand how it's affecting them in a more in-depth way, versus hearing it for the first time, or hearing it, for the first time since training or whatever they've had. But yeah, so just building that relationship and also getting in and talking about some of these things with the systems folks prior to it being an issue is really important.
Yeah, and I mean, I know that I've talked to some advocates who have said that they've tried to use the affidavit of support as an argument around ordering child support and maintenance, and they've been told by the judge, listen, this is a federal contract, this is an immigration thing, I don't want to touch it. And that's why, like you're saying, Ty, it's good to be creating those inroads early and developing those relationships with your judges, because it's not just about enforcing this contract, which doesn't necessarily involve state law. It's about like looking at the actual practical application of this.
Right.
The survivor can no longer apply for public benefits because of it. Because this abusive person has promised to keep them above the poverty level. So it makes sense.
And because of the abuse that's happening upon them, that's why they don't have the work permit. That's why they're not able to work. That's why they aren't, so everything kind of goes hand in hand. And I know in the hearing that we had gone to, the abuser was like, why do I have to pay spousal maintenance? Like, she's the one that doesn't want to be with me anymore. Like, just send her back to her country. And yeah, which was not taken very favorably by the judge. I'm kind of glad for that little outburst, because it makes the judge, it gives the judge an opportunity to see, like, whoa, this guy, like, he really does not feel like he did anything wrong, or that he has to support or keep promise on any of the affidavits that he had signed.
Yeah. All right.
Mhm.
I think we should probably move on. The only other thing I want to note, and because it came up in a phone call I had yesterday, actually, the affidavit of support does not go away with a divorce. If you have an affidavit of support between the survivor and the abuser and they get divorced, that affidavit of support is still enforceable. And so just something to keep in mind. It doesn't disappear when they get a divorce. It doesn't mean after the divorce, all of a sudden they can apply for public benefits. It continues. Okay, so I wanted to go over just a couple, and I'm going to go through these pretty quickly because I want to get to the last point before we're out of time. But here's just some creative provisions you can consider adding to protective orders when you're working with survivors who are immigrants. So the first that we were talking about before, how important the gathering of those documents can be for the immigration applications, putting something in the protective order petition about how the respondent needs to give the petitioner access to or copies of any documents related to or needed for their immigration application. Another good reason why advocates can help in determining what documents, what pieces of evidence are going to be relevant for the immigration application. Also good to talk to an immigration attorney about that. So if you're dealing with someone who you are working with someone who you think might be applying for immigration relief in the future, maybe they haven't been connected with an immigration attorney yet, please feel free to call me. I can talk through what potential documents may be relevant for future applications. Another provision could be that the respondent shall pay any and all fees associated with the petitioner and or the children's immigration applications. So I think this is particularly strong in cases where you're dealing with, let's say this abusive person maybe applied for them but withdrew the application, or they had status and so they had the ability to apply for the survivor but never did because of the abuse. In reality, they should have bared the burden of the cost of these applications, but for the abuse, they would have. And so I think that's an argument you can make to a judge in requesting that these fees be paid for by the respondent. If the respondent is claiming that the documents that we're asking be handed over have been destroyed or hidden, they're missing, asking the judge to have the respondent pay for the replacement of these documents, and then I have a couple of potential documents listed there, can be very helpful. And honestly, I think in some cases, if you're asking for judge to order respondent to pay for these documents, those documents might miraculously appear, even though they were formerly hidden. And the reason why this is really helpful is that applying for these documents can be very time consuming, and it also can be costly. It costs money to ask for replacement green cards, reprinting birth certificates, getting a new passport. That can be a big financial burden on a survivor who may already be experiencing economic or financial difficulties. And then the last one I have here is that a respondent shall not remove the children from the court's jurisdiction and or the United States absent a court order, and shall relinquish the child's passport or the children's passports to the petitioner or to the court. This is particularly important in circumstances where the petitioner is concerned about parental kidnapping or international parental kidnapping. As a control tactic, an abuser might threaten to abduct children or actually take them out of the country. And so especially if you have evidence that the abusive person has been saying these things, can be used as evidence to be asking for these particular forms of relief to keep the child safe and from being abducted or leaving the country. All of these creative provisions and these protective orders should also address the mechanics of how this is all going to go down. So if you're asking for passports to be relinquished or you're asking for documents to be exchanged, it's important to specify in these orders how, when, to whom these documents should be turned over to. I think we know if there is, if you give them an inch, they'll take a mile, that abusers may read vagueness as a reason not to provide those documents or not to comply with the court order. So to try and be as specific as possible around the details as to how those things should be done. Ty, do you have anything you want to add to that before I jump into our last topic?
No, I think you covered a lot.
Okay, and there's, I mean, I went through it relatively quickly. Always feel free to call and ask questions
Yeah.
about that.
And I'm just kind of being mindful of time because we've only
Yeah.
got a couple more minutes left. So,
Yep. This last part, I'm going to go through it relatively quickly, but I have received quite a few questions about this, so I just wanted to make sure to touch on it quick. So when a parent is applying for a minor child's passport, and when I'm talking about minor children here, they need parental permission if they're under the age of 16. So if they're applying for a child who's under the age of 16 to get a US passport, this can be very difficult if you don't have the consent of the other parent. So I actually have a printout, and there is more specific instructions on the Department of State's website around applying for passports. But it says on the Department of State's website that both parents or guardians must authorize the issuance of a child's passport. The best way to do this is for both parents or guardians to go with the child in person to apply for the passport. So obviously, when we're dealing with abusive situations or situations where the other parent is around, this can create a lot of difficulties and barriers for applying for the children's passports. So the first and important question that you should be asking yourself is, who is listed on that birth certificate? Because that's what they're going to look at to determine who or whether or not there are identified two parents. So if only the mother is listed on the birth certificate, they don't need to have the other parent's permission to apply for the passport. They can apply for the child's passport on their own. However, if both parents are listed on the birth certificate, then the Department of State is going to want the other non-applying parent's consent or one of the following documents that I'm going to discuss. So if there is a cordial enough relationship that the non-applying parent, the other parent, is willing to file or complete a consent form, that's form DS 3053, they can complete that, and that provides the Department of State with understanding that this form, this other parent does consent. They're just not able to go with them to the appointment to file for the child's passport. If they're not in the country, it can be a little more complicated because it needs to be notarized, this consent form, which can sometimes be difficult in other countries. And in certain countries, and there's a listed countries on the Department of State website, it may require them to get the notary at a US consulate. So important to look up that information. Let's say that there isn't a cordial relationship, that other parent isn't willing to sign this consent form, then some other options may be that the parent who's applying for the passport can file for full legal custody, either through the order for protection or the family court process, in order to provide that information to the Department of State to say, hey, look, I have this court order that says I have full legal custody, so therefore I am the sole decision maker as to whether or not this person can get a passport. So when you apply, when you submit the application, you would submit the court document that shows that they have full legal custody along with the application. I've talked to advocates who told me in the past, order for protections that provide full legal custody to the parent used to be sufficient. That used to be enough for applying for a child's US passport. But they said recently they've been having troubles getting passports issued with order for protection custody orders because it's not a permanent order. And so what happened in that particular case that I'm referencing is that the advocate asked the Department of State for a 90-day extension in order to provide more finalized custody documents, and then they started the formal custody process in district court. And the judge was able to provide them with a temporary order to submit to the Department of State office, which said this parent has been given authorization from the court to apply for the child's passport. I also want to note that I don't think this is happening in all counties or all districts self-help centers, but the 4th district, the Hennepin County Self-Help Center, has documents around filing a motion, not necessarily to address custody, because I think we know that can be difficult in cases where there's been abuse, but it's a specific motion asking for permission from the court for this parent to apply for a passport only, not to necessarily address custody or parenting time. So there are sample documents in the 4th district's self-help center, but if anybody wants copies of those documents, they can certainly reach out to me and I can provide them as well. And then the last possibility is to file, and I don't have the form number there, it's DS 5525, also called the Statement of Exigent or Special Family Circumstances. So on the Department of State website, it says if you can't locate the other parent or have no ability to get them to sign a consent form, maybe because they've been deported, they are, unable to find out where they are, you may file the Statement of Exigent or Special Family Circumstances asking for the passport to be issued anyway without the consent. It also states that if you have a restraining order, a domestic abuse conviction, or proof of deportation, you may be able to file that with the Statement of Exigent or Special Family Circumstances form as well. I have been told that there is not a great amount of success in getting passports by filing the Exigent or Special Family Circumstances form without significant amount of documentation of those exigent or special family circumstances. So it may be worth trying, but from what I've heard, it hasn't been wholly successful in the past. Whew, I went through that really quickly. Ty, is there any quick questions about that?
No questions.
Okay, well, sorry everybody that I had to go so fast through some of this information, but just always know, as Ty has said before, Ty is available and willing to answer questions, and I'm available and willing to answer questions about anything we've talked about here today or any other immigration situations or questions you have coming up in the course of your work.
Okay.
Anything you want to add, Ty?
No, so Rachel's contact information is on the last slide. I didn't put any of my contact information on there, but that number, the 612-343-9842, that does come directly to Standpoint's office. And so I, most of the time, am one of the advocates that does answer the phone. So if you have any questions, please give us a call. I'm going to go ahead and end the webinar now because we have gone over in a couple of minutes. But thank you for joining us.
Thank you.